First, I would like to perhaps have a broader view of the situation we are in today, and in particular looking at the recession that we are coping with, which is the worst in decades. I was discussing with you a bit earlier. You were telling me that in the Times today in Ireland, there was an announcement that the economy in Ireland would be contracting by 9.4% in 2009. In this context, I think that everyone is affected: companies, households, workers, and individuals obviously also pay their share of the costs. And today we are here to look at what are the solutions in this context. And obviously we believe that the solutions which are taken to these short-term huge challenges should be relevant as well in the middle run. And I think it's one of the important issues for the European level today to, at the same time, find appropriate ways to respond to the crisis, but at the same time to continue our more structural efforts to reform our economies and to make sure that we are competitive. When this being said, I think on the labor market, we should not discuss social aspects and social issues in isolation. We should always start the discussion with taking into account these economic challenges that I've been referring to as an introductory part. And for this reason, we think that as Business Europe, the appropriate way to respond to the challenges today is a four-pillar strategy. And this four-pillar strategy is to start with access to finance. Without access to finance, there would be no way that an economic recovery is possible. Just to inform, I see that you look at the screen. I don't have any slides, so it will be a presentation so that you know about it. The second pillar of this strategy would be to launch some recovery programs. It has already been done, and we acknowledge the efforts made in the countries, 1.5% of GDP, and obviously the coordination at European level, which is taking place. But in this, it's important that we invest these resources in basically where it would have some added value for the future: infrastructures, research and development, innovation, and improving the labor market functioning play a central role in this as well. And here, obviously, we should not focus only on the short term, but look at the structural changes which are basically requiring some important shifts in policy making. And here I refer to the changing world we are operating. Globalization has obviously a big impact on the capacity of Europe to sustain its social protection systems. And the fact that we are in a crisis today does not mean that we do not have these challenges anymore. To the contrary, we are facing the same challenges, but they are worsened, and we should never forget them. So it's very important when we look at the social aspects to invest in the future, to invest in education and training, in human capital. This is where the future is. And the last point that we advocate for in our strategy is obviously to fight against all forms of protectionism. On the labor markets, the Business Europe, we develop every 2 times a year an economic outlook, and we have, from our member federations assessment, identified that in 2009 there would be around 4.5 million of jobs which are going to be lost in the EU. So the challenge is huge. There are countries in which it is worse than others. In the UK there would be 850,000 people who are going to become unemployed, but it would be even worse in Spain, where the unemployment rates are already very close to 20%, and where 1 and even a bit more million employees are going to lose their jobs. So the response to this is certainly to look at the conditions in which companies can create jobs, and for this, flexible labor markets are key. And I would like to highlight the fact that flexicurity, that was developed in 2007 at European level, you perhaps know about this concept, as it has been widely discussed, and it's certainly one of the issues as well which is tackled in the member states at the moment. is more relevant than ever before during times of crisis. Why is it so? Because this crisis shows all the difficulties that we are trying to respond with flexicurity, which is to at the same time give flexibility to companies and at the same time provide for security to workers. And this balance is a very hard balance to achieve, but at the same time, this is now that we need to achieve it because the needs on both sides are very real and they need very adequate solutions in the short term. So we really want to support flexicurity and hope that this would be a good way for making progress. And in the member states today, we've seen in the last few months a series of short-term measures which have been taken in order to respond to the crisis. And for instance, we would support, as Business Europe, the type of measures such as working time flexibility measures which aim to maintain employment where it exists. We've seen some schemes like short-time working which have been developed in many countries, and it seems efficient, but the question is for how long? And when we look at the prospects, economic prospects and also labor market prospects, it is not sufficient. So another very important dimension which relates to what I just said on the need for the conditions to create more jobs is to keep wages as well as non-wage labor costs under control. And this is the only condition which will allow companies to basically go for a new upswing, to invest and to be able to increase their workforce. But at the same time, obviously, when we look more at the structural elements that I was as well taking into the loop in my presentation, education and training is vital, and we need to invest more in this field. And this is even more the case during the crisis, where we have seen in some circumstances in some member states that the short-time working schemes, for instance, were also used in order to foster education and training for workers which are concerned by these schemes. So obviously the situation is serious and there are tensions on the labor market, and we are conscious about the realities facing employees. But at the same time, what I try to show is that it is not only employees suffering. Companies are obviously at stake, and their future operation is really put under question today. So we need to find the right balance. And on this, I just wanted to mention that certainly the type of actions which have been taken, for instance, in the UK recently against the legal employment of foreign workers coming from other EU countries is not the right example. There are problems, there are difficulties, and solutions need to be found both in the short term and the middle term. But this is not a solution to put it and to basically exclude others and not to see the value that we have in a single market and the benefits that we take from it. So I will now come a bit more in depth into the discussion of today, which is ECJ rulings, but I think it was very important to set the scene for our discussion. And we have 4 cases, and these 4 cases are somewhat different. The Laval case concerns a Latvian construction company whose site was blocked by the Swedish trade unions in order to force it to sign their collective agreement and to enter into negotiation on pay. Viking concerns a trade union action to prevent a company from reflagging a vessel from Finland to Estonia. Ruffert is about a German regional law on the award of public contracts, which imposes on contractors to pay the remuneration laid down in the locally applicable collective agreements when a generally applicable collective agreement already exists at federal level. And the Luxembourg case regards the compliance of the Luxembourg's national transposition law with the public policy provision of the Posting of Workers Directive, and also on the control measures which are asked from companies. This being said, there are commonalities in these cases, obviously, and I would like to focus on 2 issues. The first is the right to take collective action, and the second is the Posting of Workers Directive. And I will make a few comments on these 2 issues. On the right to take collective action, I think we should never forget that although it has been a very big issue for the trade union, this is the first time that the European Court of Justice has said, has written, that the right to take collective action is a fundamental right. So this is a progress and should never be forgotten, although there are different views on this. When it comes to Laval and Viking, it's also very important to understand that this has no impact on the trade union rights to take action on purely domestic situations to negotiate working conditions for domestic workers. We are speaking, when we look at the posting of workers issues, about 1 million workers for the EU. This is important to remember it. For us, as employers, the proportionality test, which has been proposed in the Viking and Laval cases, is the right solution. And this is the right relationship, the right balance between social rights and economic freedoms. The reason is that the right to take collective action should not be superior to other EU law of equal value. Why is it so? Because it is so for any type of right. Freedom of speech is a fundamental right. Don't you agree that when you exert your right to your freedom of speech, if you offend someone else, you have a limitation to your own right? These limitations are necessary because there are different interests and there are different realities. The second point that I want to make is that the right to take collective action is not superior to other EU law, such as the freedom to provide services and the freedom of establishment. And in this, obviously, as companies, we greatly value the single market integration. And on this, we should never forget that single market integration is not only an economic success, but it has been a source of social progress. It helped to create 275 million additional jobs. It added to GDP to an extent of an overall increase of 240 billion euros, but also, if you put it per capita, 520 euros for every EU citizen have been raised thanks to single market integration. So we should not forget that this is very positive, and we should therefore not be perhaps so reluctant to look at these economic freedoms, which are social progress for many of us and for basically the societies we live in. When it comes to the Laval case, I would also like to highlight one point. The Latvian company was ready to pay the minimum wage, which were set at a level of 11 euros per hour in this case. And the Swedish trade unions were asking for the application of average wages, which was around 16 euros per hour. And it is true that the Posting of Workers Directive sets minimum protection and a nucleus for mandatory rules. But these mandatory rules do not relate to an average salary. They relate to a minimum salary. And I think it's only fair that it relates to a minimum. So there is here, I think, a misunderstanding in the sense that is it fair that the action of trade unions for the application of average wages can lead to the bankruptcy of a company? It's a question mark that I pose to you. Is it logical? Because this was the case of the Latvian company. Our conclusion of all this on the right to take collective action is that the ECJ rulings reflect the way in which two legal norms of an equal value interact, and therefore proportionality is needed. They do not affect the right to conclude or the content of collective agreements, but made it clear that the right to take industrial action is a fundamental right. Companies oppose the addition of a social progress clause in the treaty because we believe that this would give to social rights primacy over economic freedoms, which is obviously not welcome. We need to have a balance. We don't need primacy of one of the two sides. So thank you very much for your attention. And I was happy to be here in Dublin with you today. Thanks for the invitation.
I wanted to talk about workers' rights and economic freedoms. That's where basically the issue. Just to go quickly through a few things that we all know, but that are very important to see in terms of background. You can't deny that we are in the middle of a financial and economic crisis with unemployment on the rise, but climate and energy problems that will undermine the EU prosperity, demographic challenges, enormous changes also on the level of families in terms of the feminization of our workforce, migration from outside, and mobility within the EU. Just a few examples of what I recently encountered: Mongolians and Vietnamese in the Czech Republic, Chinese workers in Romania, Romanian workers that went to Spain but are now going back because of the crisis to Romania, and Romania in big problems what to do with all these people from Far East and how to manage with their own workers coming back, and no employment because the foreign companies that invested in Romania are now withdrawn. Just a very small example how we are all hit. And around Europe, very young demographic areas in poverty, people that are looking for better chances, and we will see poverty increasing because of the crisis, especially outside Europe, and therefore even more pressure on immigration and migration flows. That means that let me just find out if this wants to do what I want to do. That's it. So, if we discuss the issue of today, we have to discuss it in this framework: how to deal with the excesses of capitalism, with rising inequality, precariousness on the rise, people, local people, all people, feeling increasingly insecure, and protectionism, nationalism, and xenophobia lurking in every country, I would say. If I then go to the issue of free movement, and first of all free movement of workers, as opposed to the other free movements, it is our workers' right, I always say. This is the right of a person, a worker, to move around the EU and be treated equally. This is a fundamental issue when you look into the treaty provisions on free movement of workers. No discrimination on the basis of nationality, very clear equal access to social support, and also being treated equally by your employer in the host country. And that's also why transitional restrictions were not exactly the right answer in our view. We have taken a very clear position on that as an ETUC in recent years, saying that the free movement of workers basically should only be restricted when you really know what you're doing and if you really need it, and otherwise please don't, because if you do, you may have an unwanted effect to increase the free movement of services. Which is that you move the same worker but not directly to the host country employer, but via an intermediary or a service provider, which is what we have seen increasingly. The support for free movement of workers, also in our own membership, is increasingly undermined by deregulation. Many countries that increasingly have tried to deal with economic challenges by saying, let's flexibilize the labor market. If we can't flexibilize monetary policies or other things, then this should be the answer. Precarious jobs, outsourcing, subcontracting, undeclared work, it's all happening everywhere in Europe. National systems that are not mobility proof, in my view, a very important issue. It was also mentioned by the previous speaker. This is not only about the EU, this is also about how our national systems deal with the fact that there is increased mobility. The mobility of workers as services, increasingly replacing the free movement of workers, and internal market rules invading national social space. And that is the picture that is very much influencing positions of trade unions on free movement in general. I showed here this Viking line, and I have no time to go into the detail. What I wanted to mention about this case is, don't forget that the case started with a small Estonian union, a small Estonian Siemens union, 1,600 members only, organizing workers on ferries. And the Siemens union was confronted with the Viking Line, big Viking Line, that wanted to negotiate its re-establishment, its reflagging to Tallinn. And this little, very little union said, I'm a member of the big International Transport Federation. We have a policy on flags of convenience. I'm not going to negotiate with you. You should go back to the Finnish Siemens union because you have to negotiate there where your ship is beneficially owned, as they say. And that started the whole case, because then the Finnish union said, well, we can't be against reflagging, but we want to negotiate the terms. And of course the terms had to be the Finnish terms and not the Estonian ones. And then another important element of this case, the forum shopping. The ITF policy was involved, so Viking Line thought, well, much better to go to a UK court than to a Helsinki court to discuss this matter. And where in the first instance they also got an injunction against the unions. And then we finally got this case before the ECJ. The Laval case, where I just wanted to mention that the Latvian company may not have been a really Latvian company. It was a subsidiary of a bakery in Latvia. So there was a subsidiary in Sweden. Was it really posting workers? It posted 35 construction workers to a Swedish construction site, refused to negotiate a collective agreement according to the Swedish rules, was supported by the Swedish employers to go all the way up to the ECJ to challenge the Swedish collective bargaining system, which is quite something. The Rufford case, you heard about it. Just another small detail. The main contractor in this case was a German contractor who subcontracted the work to a Polish one. The German contractor challenging German public procurement law before an ECJ, saying that there was a EU dimension because it was hiring a Polish subcontractor. That's where it started. That's where a lot of unions start asking themselves, is this what the EU treaty was written for? Is this what the free movement of service should protect? The Luxembourg case, you can't read what is below there. I just, apparently some mistake in the slide, but it says that in the posting directive you are allowed to also impose public policy provisions, and the interpretation of the court was that the member state cannot just decide itself what its public policy provisions are. Be aware that Luxembourg is a country where 40% of all its workers are foreign. Portuguese workers, which are long-term immigrants, and they, on a daily basis, people coming from Belgium, Germany, France, all around Luxembourg, a very small country, a country that wants to properly regulate this enormously mobile labor market. This is how we felt. And this is what my boss very often says. When you would talk in terms of a football match, it's 3-0 for us or 3-1, depending on how you interpret the case. Capital versus labor, balanced. The Vikings case, the court says, I'm balancing all these nice things. We don't think it's really balanced. Yes, very important. The right to collective bargaining, collective action is a fundamental right recognized by community law. But as soon as we exercise it, and what can you do with a fundamental right if you do not exercise it, then it can be seen as an obstacle to economic freedom. It must be justified and proportionate. And don't forget it has a horizontal direct effect, this Article 49 and 40 establishment. Which means that every company that doesn't like trade union action can say, there is a transnational dimension to this activity, to this action, and I think that you are, your action is an obstacle to my free movement right. And that can create enormous problems for us. Services versus workers, a similar thing. I should have said 4-1 because I forgot at the bottom the Luxembourg case. Okay, yes, little recognition. If we want to protect workers against unfair competition on wages and working conditions, this can be justified. Thank you very much. But if we then look at the posting directive, it is interpreted, the posting directive is interpreted as an exception to Article 49, so it defines exactly the scope and not more of what we can do. We can take action, we can protect until the minimum standards and not more than the minimum standards of the posting directive. These standards must be laid down in very precise manners as described by the posting directive, because otherwise we have a problem. Public procurement law as such is not recognized as such a standard, and public policy provisions, as we saw in the Luxembourg case, also to be interpreted very narrowly. There's a lot of fundamental questions, I can't answer them here for you, but do we see a balance here, as the court says, or do we see hierarchical order? Market or fundamental rights first? We cannot otherwise then interpret this as market first. What is the real relation between the EU treaties and the Charter of Fundamental Rights? And there we have the snake that bites in its own tail. Yes, we have the recognition of the fundamental right of collective bargaining, etc., in accordance with community law, says the Charter. Well, then, what is in accordance with community law? Then we get back to Article 49 and all the other things, and that's a problem at least. How to understand the relation between the ECJ and national constitutional courts? Be aware that in Helsinki, the Finnish law and the Finnish constitution would guarantee the right to take industrial action in the Viking case, fully. But the ECJ had some remarks about it. Either in Sweden. In the Rifford case, the German Constitutional Court had said public procurement law, doing what you are doing in Niedersachsen, is perfectly okay in terms of the German Constitution. And then, of course, we have a very important question: how does the EU treaty and how it's interpreted relate to international social standards, Council of Europe and the ILO? And those issues are increasingly important. I can tell you that we have some very interesting recent verdicts from the Council of Europe, Strasbourg Court, recognizing that the right to collective bargaining, and the most recent case, even the right to strike, is a part of the famous Article 11, which is the fundamental right to freedom of association. So, this is then how many of us think that we are somehow eaten up by these mice from the European level that are eating away our national standards and industrial relations guarantees, if we have them. This is the issue. Is collective bargaining, collective action, national labor law, is it an obstacle in itself until it is proved to be not an obstacle? It leads. We have had enormously a lot of articles from academics, lawyers and others, and especially in countries like the UK, I think Ireland might be a similar one, where the right to collective action and collective bargaining is not that strongly embedded in your system. The use of interim injunctions to stop industrial action even before it has been taken. That as such is already having an enormous impact on trade unions and their policies and their attempts to protect workers. Especially when it could give rise to enormous damage claims. I don't know if you've heard about the famous Balpa case. British airline pilots tried to have a collective action against British Airways, and British Airways said this has some Viking dimension, and the damage claims could have gone into the millions. There is limited definitions of what are legitimate interests for us to defend and support workers. Who are they that they can define what are our legitimate interests to defend workers? And the principle of proportionality is also giving rise to a lot of debate. Now, for us, the issue is really, what can we do and how do we make this a more political issue? And that's what I call safeguarding mobility by ensuring proper conditions for free movement. And safeguarding in a double way. Safeguarding is, yes, we are in favor of mobility. It should be possible. We are not against the free movement of workers, services, capital, or goods. But we should discuss conditions. And the basic principles of everything should be equal treatment and fair competition, which you can also find in the preamble of the Posting Directive. We must also really have another debate at national level how to make your national systems mobility proof. But that's not sufficient. Without EU rules of the game, the national systems will always be tested against the internal market. So we have started to discuss strategies at all these different levels. What at EU level? We think that we really need equality of arms between capital and labor, and not capital to have every kind of freedom, and its freedoms never tested against proportionality or fundamental rights, and labor being with its hands bound on its back. We have started to discuss the social progress protocol to be attached to the treaties. Why do we think that is important? It has political importance and it has legal importance. The political importance is that we think it's high time in all the debates about Europe to focus again on the fact that the EU was about social progress. Why did countries start to work together? Yes, they thought that to have an internal market would help those countries to prosper. But to prosper was for their populations and not just for companies to have big profit. The issue was working together, having welfare growing, having the economies growing that would benefit everybody. And if you look into the Lisbon Treaty, you can even find more clear language than in the current treaties that we should have a social market economy and that it is that we are working together for social progress. Is that enough? No, we don't think it's enough in legal terms, because apparently with all these things around, the ECJ interprets the treaties as it does. So we think it could be clarified, not against the current treaties, but to clarify this message in the treaties by a clear and binding protocol in which we say, well, this is how you have to interpret the treaty. The balance that the ECJ in the Viking case says it is applying should be, let's say, more clearly applied also to the treaty. The obligation to interpret it in a balanced way. We have the issue of the revision of the Posted Workers Directive. I will come back to that shortly. Safeguards for member states that should also be established at European level, that they can maintain national labor law and industrial relations and more and better social regulation at EU level. I know I have limited time, so I will just show you here this issue of EU rules of the game. Let's not forget what free movement of workers was about, which is really this whole framework, host country principles, equal treatment, etc. Very important. Then we get to the EU rules of the game about the problematic part, which is mainly in the area of the free movement of services, where we have minimum standards rather than equal treatment. And we have an important area for problems, which is the monitoring and enforcement of labor standards, where we see weak national systems, lacking instruments, and if they have strong instruments, they are challenged as obstacles to the free movement of services. So this is what we said about the social progress protocol in a little bit more detail. The single market is established for social progress. Economic freedoms have no priority over fundamental social rights, and maybe even the other way around. And economic freedoms are not a license for avoiding or evading social regulation or unfair competition. The exercise of economic freedoms must as well be justified in the light of fundamental rights, and not only the other way around, which is what we think is the unbalanced part of the court decisions. Why we only should justify what we do, and why companies should not justify. Can they really invoke the free movement, the freedom of establishment, or the freedom to provide services, when what they basically do is avoiding regulation? just establishing them 20 kilometers further because it's on the other side of the border, and therefore they all soon are a cross-border service provider, is in our view should not be protected by the treaty. It doesn't mean they cannot re-establish themselves, but they cannot invoke the treaty to protect them against trade unions. We really think that we need a rethink on the rules on workers moving in the framework of services. I'll finish quickly. This is a very important part of the debate, how to make the national system mobility-proof. We think it's a major mistake, if I look at it from my Brussels perspective, that Ireland was not capable to find a solution for its own national debate on how to better protect collective bargaining and collective action. Employment law, if you don't have proper regulation covering atypical forms of contracts, you are very vulnerable in situations of cross-border working, temporary agencies, all the outsourcing and subcontracting issue. Adequate labor inspection, we see most countries reducing the amounts of money going to labor inspections rather than increasing them. A legal minimum wage is in several countries a big issue, like Germany, as one way to deal with the increasing challenges. And, as I said before, shields against the internal market tests to protect your national systems. We also have an important task ourselves as trade unions. I will not go into the detail, but we clearly need to coordinate better our collective bargaining strategies and organize all those workers involved. We are also very vulnerable ourselves when we just have opinions on what is happening to those people and not organize them in our own ranks. We have the free movement of workers as a fundamental right. I always say it doesn't mean that everybody must move. We also should have a right to have our national countries invest in our national employment and prosperity. And we urgently need a major effort of confidence building. We do a lot of talk about confidence building on the financial markets and capital and all that. The issue is confidence building vis-à-vis our populations. And to do that, you really need to offer them visible protection against what's happening and all the change. And if you don't do that, you cannot avoid, and we cannot avoid, that our membership is turning nationalist, protectionist, and xenophobic. And that is a major threat for, in many countries, and also for the EU project, and something that we as trade unions are very worried about, and many of us are involved in how to deal with that. So we need a new vision for Europe, and in that we need to recognize that open borders need confidence, protection to prevent protectionism, and not protection to be seen as a form of protectionism. We ask for a new social deal, and the priority number one is to strengthen the social dimension of the EU.